Welcome to Hurt at Work, a Kentucky workers' comp podcast. Today, Louisville workers' compensation attorney Scott Scheynost is going to provide helpful information, tips, and advice for injured workers and their families. Scott's goal is to help you to maximize the benefits you receive. If working's got you hurting, sit back and listen to Scott address topics that matter to you. Friends, welcome back to the studio. I have workers' compensation attorney Scott Scheynost, and today we're going to talk about what to expect from your workers' comp claim. Scott, welcome back as always.
Good to see you again, Jim.
Absolutely. Glad to have you here. So let's jump into this. One of the things that we have stressed in the previous episode, and we've stressed along the way when it comes to workers' comp, is when you're injured, you have to notify your supervisor, and that's required by law, right?
Right. I've had a lot of people ask me at the beginning of these, what can I expect? Well, number one, you got to prove your case, which is you got to put your employer on notice that you were injured. The law actually requires that. And sometimes I'll see people 2-3 months after they were injured, they haven't told their employer, and we have an issue. Sometimes we get around it, sometimes we can't. But you have an obligation to let your employer know as soon as possible that you got hurt at work, how you got hurt at work, where you got hurt at work, all those kind of things, because they have a right to investigate it. They have a right to make sure you didn't get hurt playing basketball or didn't get hurt in a car accident or working for another employer. And the longer it takes for you to tell them that you got hurt, the harder it's going to be for you to prove your case. So first, in your workers' comp claim, you got to expect to tell your employer that you got hurt. Let them know as soon as possible. And if you don't do that, then we've got a lot of other issues we're going to have to deal with down the road, and you may not be able to deal with them at all because that might just shut your case down.
Right. And to be clear, that's not a colleague. That has to be somebody kind of up the food chain.
You have to tell somebody that's in a managerial position, a supervisor, a boss, somebody in safety management, something like that, that has a obligation to report it up the food chain. If you tell a fellow coworker that you got hurt, that's evidence you got hurt, but it's not complying with the notice.
Well, and that would also apply to your union steward if you're in a union shop, right?
Right. Union stewards are not part of management. They're considered fellow employees for this purpose. So you need to tell the boss, the team leader, the supervisor, whoever is your person up the chain of command, and the higher up probably the better. But you need to make sure they know. It's also a good idea to write it down somewhere, who you told, what you told, and when you told them. But first of all, you got to expect to give them notice. So some people don't want to tell their employer they got hurt at work. Well, that's an issue because if you don't tell them, then we're not going to be able to go anywhere else with this. So you've got to put them on notice. You've got to expect to tell them that you got hurt. And I want you to do that as soon as you possibly can.
That makes sense. Now, in this, you're also going to hear us use the term workers' compensation carrier. That's basically the insurance company who's responsible to pay the bills, right?
Right. Kentucky law requires every employer to have a workers' compensation insurance carrier. They're the ones that actually pay the bills, investigate the case, look at your medical records, pay the doctors, send you money, temporary total disability benefits for being off work. You've got an adjuster. The adjuster is going to have a claim number. That claim number is kind of your magic key to getting workers' comp benefits, because if your claim has not been reported to a workers' comp carrier, you're not going to be able to tell the doctors who to bill. You're not going to get any money from being off work from the workers' comp carrier. So if you give notice, the employer is supposed to turn it into the workers' comp carrier, and if that happens, then you'll get assigned an adjuster. They'll give you a claim number, and that's like your magic key to give the doctors and everybody else you deal with to get things paid. If your doctor does not have a claim number, if they don't know the insurance company, if they don't know where to send the bill, guess who's going to get the bill? That's you. And you're going to call me, what I'm going to do with the bill? Well, we're going to have to get it to the claims adjuster. So sooner or later, we're going to have to get that information. Now, if your employer won't turn it in, there's ways you can go around that. The Kentucky Department of Workers' Claims has a computer database with all the employers in Kentucky and all the employers' workers' comp carriers. So you can call the Kentucky Department of Workers' Claims and get that information. If your supervisor doesn't like you, doesn't want to turn it in, doesn't want to mess with the paperwork, they're going to lose their safety bonus because you had an injury and are going to wait till the next quarter to turn it in. If something like that's going on, you can do an end run around them and contact the Kentucky Department of Workers' Claims. In those situations where the employer has not turned it into the workers' comp carrier, that's actually a violation of the law. They can fine the workers' comp carrier and the employer for what they've done. Sometimes it takes somebody from the state to tell them that, and that generally jumpstarts the process. But you've got to turn it in, give notice, then you've got to get this information to unlock your benefits. The claim number is how you do that.
Well, friends, that's an important, that in-run option that you have is something that's important to know about. And I'll put a copy of that link to that department, some information so you can easily contact that department in the show notes below where you're listening to this. So if you're listening to this podcast, you notice there's a whole bunch of paragraphs and stuff below the actual recording. Those are the show notes, and I'll make sure we have that link and that contact information right there.
Great.
We also want to talk about the medical treatment because, again, we're kind of giving people an overview of what's going to happen with this claim. And so medical treatment's a huge part of it.
It's the biggest part usually in a workers' comp claim anymore. In Kentucky, your employer pays for all your medical treatment and expenses related to the injury. That's with the doctors, hospitals, MRIs, x-rays, ambulances, mileage expense to go back and forth to the doctor, prescriptions, you need a brace, need a wheelchair. God forbid you're hurt so bad that the whole house has to be modified, but that sometimes happens. Any medical expense related to your work-related injury is covered in Kentucky by the workers' comp carrier. Now, besides getting the medical treatment, I always think it's a good idea to go to the right provider for the medical treatment. A lot of times what you can expect from your workers' comp carrier or from the employer is something like, you got to go to our doctor. Now, that's not the law in Kentucky. I hear that a lot. I hear that people said, my boss said I got to go to their doctor. The insurance company says I got to go to their doctor. That's not the law in Kentucky. In other states it is. I'm not going to go into whether or not these people actually know what the law is and are intentionally deceiving people, but the law in Kentucky is you get to pick the doctor you want to go to.
And why is that advantageous to the injured worker?
Well, if your boss, if your employer, if your workers' comp carrier is asking you to go to a doctor, there's usually a reason. And the reason is they think they can expect money and they're trying to manage your case from the very beginning. Some of these providers know who sends them referrals. Some of these providers want to keep that business, and they tend to make the referral source happy because that's how they get their business.
So they may actually lowball the extent of your injuries. I mean, it happens.
Well, I don't know exactly what's going on, but it seems to me the standard of care is better with somebody that you pick than if you are sent to a particular provider by your employer or the workers' comp carrier. Now, if you go to your family doctor, they're into this to take care of you. They want to practice medicine and make people better. They don't really care. They're usually being underpaid by the insurance companies anyhow. They don't care who's sending them the referrals. They're into this to make you better. So if you can go to your family doctor, I think that's usually the best thing because that person knows you. They're going to want to take care of you. They know a little bit about you ahead of time and what might be going on or not going on. And they usually have your care, your health, your welfare number one in their minds. They're not worried about getting referrals from somebody else. They're not worried about the plaintiff's attorney sending a business. They want to make you better. That's why they're doing that. So if you can get to your family doctor, I think that's the very best thing. If you can't get to your family doctor because they're smart enough not to take workers' comp cases, then you still need to pick somebody else out.
Well, and you've been practicing workers' comp law here in Kentucky for the last 35 years. I mean, you may be able to offer some suggestions, but ultimately the client's got to make that choice, right?
I can give you names of people I like. I really do like it when you go to your family doctor better.
Absolutely.
Because, the opposite of the insurance company sending you to somebody is the plaintiff's attorney sending you to somebody. So, you want to get better. The money we get in workers' comp, I think, is a far cry from what people deserve. I think probably the best benefit from the workers' comp system is your health gets restored. So if you're going to your family doctor, I think that's usually the best thing for you. And in the long run, the best thing that's going to happen to you. And that physician is going to try to take care of you, and you're going to get the best care that you can. But again, expect your workers' comp carrier, expect your boss, your employer to tell you you've got to go to a doctor. That is not the law in Kentucky. There's some things that you sometimes have to do that might influence the doctor you go to. Sometimes the employer's in what's called a managed care plan, which is like an HMO for workers' comp injuries. But even then, they can't tell you which doctor to go to in that managed care plan. You have to go to a doctor in that plan, but you get to pick the doctor. So if an employer, workers' comp carrier, nurse case practitioner that's assigned to your case tells you to go to a certain doctor, I like to say write that doctor's name down. Make sure you never see him because there's a reason they usually want you to go there. So, you're usually in much better situation if you can pick the doctor, and that's probably the best advice I can give you because that happens at the beginning of the case. And that doctor will be in charge of your treatment for the rest of the case. And this could go on for years. And you could have many operations sometimes. So if you've got a doctor that you trust that wants to make you better at the very beginning, your life's going to be a lot better at the end too.
That makes
But
sense.
expect them to tell you got to go to a certain doctor. And if you call me up, I can give you the site that says no. We can give you the number for the Kentucky Department of Workers' Claims. You can call them to verify that. And I'm amazed at how many times I've talked to people, probably 2 or 3 times a week, where somebody's been told they had to go to a certain doctor, and they go, no. You mean they were lying to me? Well, I don't know if they were lying to you, but that information is not correct.
Right. Let's just be nice and call it what it is.
They could have gotten the information wrong. I'm not going to say somebody's a liar, but that information is not correct.
No, that makes sense. Another thing that goes along with a workers' comp claim, when you're talking about getting the treatment, getting the medical care that somebody needs, they may not be able to stay local. They may have to travel. And anytime somebody travels for medical care, they have expenses, and those expenses can be reimbursed. So let's talk about reimbursements.
Yeah, if you are getting medical treatment, any medical treatment is payable by the employer. That includes mileage expense. So, let's say that you're down in Campbellsville, Kentucky, where my grandmother's from, and you got to drive from Campbellsville up to Louisville to see a hand specialist. Well, that's about, 60, 70 miles sometimes, depending on which way you go. You get reimbursed round-trip mileage for that. The law currently is that you've got to turn in that mileage expense within 45 days. My experience is most claims adjusters don't want to mess with it for a couple of reasons. First of all, it's one more thing they've got to do. They generally got a lot of stuff on their plate already. So if you're asking them to be reimbursed for mileage expense, you're probably not going to be taken care of real fast. Secondly, it increased the cost of a claim. And what I will see a lot of times, number one, is nobody will ever tell you can get reimbursed for that. And number two, sometimes they'll actually say something similar to what I said earlier about you got to go to our doctor, is no, we don't pay for that kind of stuff. Now, if you run in a situation where they won't reimburse you because they say they don't have to, I'm happy to talk to you on the phone. I'm happy to give you the number of the Kentucky Department of Workers' Claims, and somebody from there can call them up and tell them how they're violating the law. But if you do this, then you've got to keep track of where you went, why you went there, doctor's visit, physical therapy, the mileage, and they will actually go back and check to make sure you were seeing the doctor that day, to make sure the addresses match up and the mileage matches up. So that's another reason the adjuster doesn't want to mess with it, because they got to verify it. But you're entitled to mileage expense, and my experience has been probably about 55, a little bit more than half, 60% of the time, that's either not brought up or they flat out are not told the truth that they can be reimbursed for that.
Well, and this could be significant if you have to travel somewhere and do an overnight. So now you have a hotel and maybe some meals and things like that.
Yeah.
All of that can come back to you. Why should you have to pay for it, right?
Yeah. Anything like that requires expensive travel, you can be reimbursed for. And typically what we're going to see is some kind of therapy that happens 2 or 3 times a week, and especially specialized therapy. Sometimes there's only a couple places in the state. Even sometimes you got to go to Nashville for it. So anytime you're traveling, you're entitled to be reimbursed. But the kicker now is you got to turn it in within 45 days. There's a specific form, a Form 114, you can download from the Department of Workers' Claims to do that. If you do this, make sure that you keep a copy of what you sent in to the adjuster and when you sent it in, because another thing you can expect is the adjuster to say they never got the copy, okay, or they never got the fax or the email or the letter where you asked to be reimbursed. So it's always a great idea to have a backup. When we handle a case and we're sending it in, we always make sure we keep a copy of it, because it's not uncommon for an adjuster to say they never got the request for reimbursement. That's a lot easier than doing math to pay it. So keep track of it if you do that. And again, expect for that to be hard to get sometimes, but you're entitled to it, and it's your money, and we're happy to fight for it over it for you.
Well, as we continue the conversation about what to expect from your workers' comp claim, let's transition into really the extent of the injury. And because depending on what this is, how severe the injury is, it can go 2 different ways, right?
Yeah, the worst news I can give you is you got a great workers' comp claim because you're hurt real bad. But, I like to classify these in minor injuries that don't have a permanent problem and what I think are major injuries that do have a permanent problem. Let's say that you're at work and you cut your hand and it's just a small laceration. You go to the doctor, you get 6 stitches, but there aren't any permanent problems as a result of that. You don't even have a scar. In that situation, if you're off work, you get money for being off work. If you've been long enough, you get your medical expenses paid. But that's it. Okay, if you heal and after 4 or 5 weeks you've been paid for being off work and you don't have any more problems with your hand and you're basically like you were before, that's all you're going to get from workers' compensation, because we don't give out money for pain and suffering in workers' compensation. Now, if you have a permanent injury that affects your range of motion of your hand or your grip strength or sensations or something like that, that usually results in a permanent disability. And in those situations, you get more money based on the permanent disability. You also get medical treatment that might last for the rest of your life, depending on what's going So if it's a minor injury, this is going to be over with relatively soon. You probably aren't going to get anything other than medical treatment and money for being off work.
And in reality, that's kind of a good thing.
That is, because if you have a minor problem, the money you get in workers' compensation, I don't think is equivalent to what people have to go through.
Right. But at least you can get back to work and, kind of return to normal as much as possible.
Yeah, and again, the worst news I can give you is you got a great case because you're hurt real bad.
Yeah.
Now, if you're into that situation where you have a permanent disability, that's where you really need an attorney because there's all kinds of things that can happen. Besides the notification we talked about, besides the medical expenses, there's all kinds of disputes. Usually what happens is the next thing we're going to argue about is whether or not you get the surgery your doctor wants to do.
Yep.
Because in the old days, when I'm old, in the old days when I first started practicing, the person that got hurt got money that was greater than the medical expenses because of the permanent injury. Now the carriers are paying out more in medical expenses than they are to the people that got hurt. So now what happens is the carriers like to argue over these medical expenses. What are medical expenses? Well, the mileage expense we talked about before is not usually something that's going to result in a medical fee dispute, but the surgery your doctor wants to perform probably will, depending on the nature of it. And some surgeries cost more than others. So if you have a serious back fusion surgery coming up, that's going to cost anywhere from $20,000 to $200,000, depending on what they do, just for the surgery, just for the money goes to the providers and hospitals and the people who make the devices. You'll never see any of that stuff, but the carrier's paying it. So the price of poker goes up when you need some medical treatment, and generally what's going to happen is the carrier is going to fight that. They're going to have you examined by a doctor they pick out. They tend to pick out doctors that say you don't need treatment, which means that you're not going to get the treatment unless you file a claim. So if you have a serious problem, you can also expect the carrier to argue about whether or not you need some medical treatment. Sometimes their doctor agrees you need it. Sometimes they don't fight over it. I hope that happens, but I see a lot of medical fee disputes regarding people that need surgery. You really need an attorney in those situations because they're hoping that you aren't going to fight it. You're going to agree with their doctor that you don't need it, and then it goes away and they just saved a whole ton of money. But if your doctor wants to do a surgery, my experience has been you're going to generally get that despite what the insurance carrier's doctor says. And you may have to hire another doctor to rebut their doctor, but generally when you're a treating doctor that's not hired by the insurance company, when you're a treating doctor that's not hired by me, says you need medical treatment, you're generally going to get it. Now, it depends on the nature of the treatment and what all's going on, but generally the judges in the system put more weight on what your treating doctor says, who's seen you more than anybody, who's not paid $2,000 to write an opinion, who's in this to make you better. They're going to put more weight on what that doctor says than any other doctor in the system. But that's still, when you have a doctor the insurance company hires says you don't need treatment, that's their get-out-of-jail-free card. They're going to deny treatment from that point. You're going to have to fight over everything. You're really going to need an attorney. If it looks like you're going to have a serious surgery, that's probably going to happen.
Well, let's talk about impairment ratings because, again, that doctor who's been treating you, that doctor who's actually ultimately going to assign that impairment rating, once you've gone as far medically as you can go.
Yeah.
Well, let's talk about how that comes in.
Yeah, let's assume you get your medical treatment that you want. You get money for being off work while you're going through the medical treatment. You've had therapy after that. And depending on the treatment you have, it can take 2 weeks, 2 months, 2 years to recover. Let's say you get all that stuff. You won the medical fee dispute. You get your treatment. At some point, you're going to reach this magical point called maximum medical improvement, MMI. And that's when you're not going to get any better. You're not going to get any worse. At that point, if you have a permanent problem, you're entitled to a permanent impairment rating. And there's a book that tells us how to do it. Hopefully your doctor, your treating doctor, will go through this book, and they don't go to medical school to go through this book. They go to medical school to do surgery. But hopefully they have looked at this book and they're able to give you an impairment rating. Once they give you an impairment rating, then we have a really good idea about where your case is going. We also need to know whether or not you can go back to work at your old job. But once we get those things done, we generally know where your case is at and what you're entitled to receive. Now, insurance companies don't always like treating doctors' impairment ratings. They sometimes will send you to another doctor to get a lower impairment rating because it saves them money. Sometimes we have to send you to a doctor to rebut their doctor. It's kind of like a little chess game. But once we get these impairment ratings, and I've seen 5 doctors give 5 different impairment ratings for the same person.
I've always heard it can be subjective.
It's very subjective.
And that's the problem with this sometimes.
And it is a problem because it's a number they pick out, but there's a lot of different ways they can pick out the number. For instance, if you hurt your leg, there's about 15 or 16 different ways they can do impairment ratings for your leg. Leg length discrepancy, whether or not you ambulate properly, need a cane, range of motion. I can go on and on. And all these have different variables inside of them too. And then some of these range of motions require a doctor to move your leg back and forth. And it seems like the insurance company sends you to, can move your leg a lot more than other doctors can. So all these impairment ratings are different from different doctors. Doctors have certain reputations in the system, and the judges, for the most part in the system in Kentucky, know the doctors, and they can probably tell you what the number is going to be before you even see them. So I think we can figure a lot of those things out sometimes, but not every case is the same. But it boils down to getting this number, whatever the number is, and agreeing to a number. Once we all can agree to that, then we can usually resolve your case. Now, if we can't resolve your case, if nobody can agree on the number, first of all, we resolve your case. We try to get it settled for the best possible result. And there's a lot of things that go into that, not just money, but future medical treatment, vocational rehabilitation, if you're getting Social Security benefits, how this affects those, whether or not you're getting Medicare, if an MSA has to be prepared. There's a lot of different things that come into a settlement. But let's say you got it settled, and we've gone through all that stuff. Well, then it's over for right now. If we don't get it settled, then we've got to file a claim. What's filing a claim? It's a formal claim. You've had a claim with the insurance company, well, you get another claim with the Kentucky Department of Workers' Claims. You get another claim number. And when I say a formal claim, that's when we file a formal claim with the Department of Workers' Claims. This is almost like a lawsuit, but it's a little bit more abbreviated. We file these documents with the Department of Workers' Claims. You get a judge assigned to your case that's going to make a decision about it. The judge issues a proof schedule. We all have a certain amount of time to submit proof, doctor's reports, other evidence that might be submitted. The other side has a chance to rebut that. We've got a chance to rebut them. Then if the case is ripe to have a hearing, we have a hearing in front of a judge. Now, at that point, I like to do mediation before we actually get a decision, because a mediation is another chance to settle the case. And it stops us from having to do much more in the case, which means my client gets the money faster, which is usually what they want, and saves them expenses too. If we get it mediated and we get your case settled, then we're back where we were before and everything stopped. You got your benefits, your money, we go on with our life. If we can't get it mediated, then we get a hearing in front of a judge, and that's like a little trial. We have a session in front of the judge where you get to explain what happened to you. Both sides get to brief the case. That takes 60 days. The judge issues the decision. And then we have a decision from the judge, which hopefully would be the end of it, but sometimes it's not. Sometimes the judges make a little bit of an error in there. We have to ask them to fix that. Sometimes it gets appealed. And there are 3 levels of appeal for a workers' comp claim after the judge's decision.
And none of that happens quickly.
At least 9 months has been my experience, unless it's a complicated case, which can drag it on. But you can be appealed to the Kentucky Department of Workers' Claims Board. You can be appealed to the Court of Appeals and appealed to Kentucky Supreme Court. All those are at least 9 months. But after all that occurs, if we've got your case resolved, you can reopen your case.
And that can go on and on and on, depending on if you've met certain criteria, I would imagine.
Well, yeah, and that's really the thing I wanted to talk about, too, is after all this has been done, we can do it again. and I've had cases where we've done it several times. But in Kentucky, you can reopen your case if your permanent disability significantly changes. And there's a lot of things that are built into that. But essentially, if you have another operation and your impairment rating changes, that's kind of the crux of it right there. And you've got a window of 4 years from either the settlement or the final decision in your case to reopen it. And if you have this significant change within that 4 years, and we file a motion to reopen with a judge, and we basically relitigate the whole thing again, and we take proof, we determine how much the impairment ratings change, we determine whether or not you can go back to work at your old job, all those kind of things.
Well, I know a lot of people would sit back and go, wow, is it really worth it at that point? But oftentimes it is. Interestingly enough, I've had defendants reopen cases over medical fee disputes where my clients hadn't talked to me for a while and found out that they couldn't work anymore, and I turned it into motion to reopen to get them more benefits. And
we've increased our benefits 7 or 8 times, and it just depends on the situation. But people generally, over time, their medical condition is going to get worse, not better. As we get older, we get arthritis. Things just slow down, and chances are your condition will get worse before it gets better with the impairment rating. So, if you've gone through some significant medical treatment, if you've had an operation, if you had a big change in what you can or can't do, if you've had a change in your diagnosis, things change. You may have a back injury, could be also turned into something called complex regional pain syndrome. If things change, see the attorney that handles your original case. And there may be a chance that your case could be reopened. It really depends on what's going on with your case and how much money you got and what the original diagnosis was. But we can do it all over again is what it boils down to.
Which again, just extends the timeline. But as you said earlier, it may also extend your benefits.
And generally, this is a benefit that doesn't really happen in a lot of other states. It happens in Kentucky. I don't think in Indiana you can reopen your case for this kind of stuff. So this is peculiar to each state. But it is a benefit, and a lot of people overlook it. Probably the biggest thing is that it's just a short window to do it, 4 years.
Yeah.
And a lot of times, things aren't going to change that much in 4 years. But sometimes they do. And again, if you've had that surgery after your case was solved, call the other attorney up call the attorney up that handled your case and go over it with them. It's a free call usually.
Yeah.
So what have you got to lose?
Exactly. Scott, you mentioned something earlier that I want to kind of come back to, and that's the Social Security issues because, you depending on the extent of the injury, you may be able to file a workers' comp claim and a Social Security claim at the same time.
Yeah, there's a thing called SSDI, Social Security Disability Income, that anybody that's paid into the Social Security system for long enough qualifies for. And you can get both workers' compensation and SSDI at the same time. And SSDI is not the same thing as Social Security retirement. It's actually a separate program. So SSDI means basically you can't work at any job. Now, most of the time this comes into play when somebody's over 55 years old. At 55 years old, it seems to be, and I'm not an SSDI attorney, but it seems to be where it's a little bit easier to get SSDI once you reach that magic number 55. And it makes sense because it's harder for you to find a job, it's harder for you to do things, it's harder for you to be retrained. So once you reach 55, it becomes easier to get the SSDI. Now, you can get it when you're 25 years old, too. If you've had a catastrophic injury, if you're a paraplegic and you can't walk, then you're going to get SSDI when you're 25. But it's a lot harder to get before you're 55. But the bottom line is you can get both at the same time. And it's kind of weird how they interact. Workers' comp doesn't care what you get from SSDI. SSDI does care about what you get from workers' comp. And they will offset some of your benefits to a certain degree. So sometimes we can try to set up your workers' comp claim to where there is no offset. And I don't want to get too complex here, but the bottom line is you can get both benefits at the same time. And sometimes you can set up the workers' comp claim in a way to where it minimizes a Social Security offset.
And that's basically the deduction in the amount of money that you would be getting from Social Security disability insurance.
Yeah, and again, I don't want to get too complex here, but Social Security disability insurance will consider how much money you get from workers' compensation, and there's ways we can structure the settlement. It can only be done if there's a settlement, but there's ways we can structure the settlement where it minimizes as much as possible that Social Security disability impact.
And that's typically referred to as the Social Security wraparound?
That's how a lot of people talk about it, yeah.
Okay.
Yeah, and I guess the think of it as you get workers' comp and also get Social Security benefits that wrap around that too. Now, when you're talking about the Social Security wraparound, you're also talking about a thing called a Medicare set-aside sometimes. Because what happens is the employer, a lot of times, to do this, they want to completely get out of your case, including your right to medical benefits. And if you're getting Social Security disability income, or it looks like you're going to get it, and I don't want to get too complex again here too, to get rid of those medical benefits from the employer, you have to do a thing called an MSA, which stands for Medicare Set-Aside. And basically what it does is it requires the employer to set up a separate account that they fund that's used to pay for your medical expenses that you might get from your workers' comp claim. And this is real complex here, but essentially it's a fund that you don't get any of the money. It goes just to medical expenses. And if that fund gets depleted, then Medicare will start paying for benefits. In the old days, I would tell my clients that was generally a horrible idea because the way these are set up, the employers would want them to run the fund, which requires the employee to figure out how much money they're supposed to be paying under the fee schedules to the doctors, and I couldn't do that. It was just a big mess, and generally they would not fund it properly. Here lately, they've considered some things that make these a little bit more attractive. Number one, with the way they fund them, they'll consider a lot of things. There's some things that Medicare won't pay for. So when they do one of these accounts, you have to remember there's some things like mileage expense and dental treatment and optical treatment and hearing aids. If you've got an injury like that, that would be paid for in workers' comp, but Medicare doesn't pay for those things. So these MSAs need to consider those kind of factors. Another thing, too, is they will hire a company to administer them, which actually can benefit some of my clients because not only can you reopen your claim to get additional money, but the insurance company can reopen the claim to fight over medical treatment. So if you set up one of these MSAs, you've basically got a third party that doesn't care as much as your insurance carrier, workers' comp insurance carrier, about what's being paid, and they will pay most of the stuff that's submitted to them. So it makes it a little bit easier to get medical treatment. The hazard in all this is if you run out of money in the fund, and then you're exposed to having Medicare pay for things, and there's usually a 20% deductible that you have to pay for Medicare. So that's the hazard in one of these things, is that not funded properly, and it runs out of money, and then Medicare starts paying. Well, you got to pay 20% of what the cost is. Most of the time, that's not going to happen, but that's the hazard. Now, I've had recently one of my first clients. We set one up a couple of years ago, and we set up a fund, and he never used any of the money in the fund, and it had a sizable balance. And what happens when he passes away? Well, we had that set up to where that would go to his estate. And I've tried to do that in most of my cases here where people are interested in it. This is the first one I've had where somebody's actually passed away and the money's come back into the estate. But a lot of times the carrier won't want that to happen because they want to get the money at the end of this. But that's another way some people have actually used that as a way to fund part of their estate and pass on to their children as inheritance, is having the unspent money in this thing go to them.
But again, all of these are complicated topics.
Complicated.
This is another reason.
I know somebody's snoring right now listening to all this stuff.
Well, yeah, but it's a good reason to get an experienced attorney. And again, Scott, you've been doing this for 35 years, right here in Kentucky, off Dixie Highway.
One other thing about that 35 years that goes to expecting stuff is the law will change.
Well, and that's the final point. You know, and that's the one variable that none of us control.
Yeah, I've done this 35 years, and I think there have been about 4 or 5 major changes in the law since I've been doing it. And I started in 88, and the change in law in 87 was the biggest change probably. But when Frankfurt meets and the legislature gets together, they try to, seems to me, minimize as much as possible workers' comp benefits. And I've yet to see them really expand benefits, but I have seen them kind of chip away at different things. Right now in Kentucky, you have future medical expenses for the rest of your life. Now, about 5 years ago, they said, well, you get future medical expenses, but you got to prove after 15 years that you're still entitled to it, which means you've got to fill out a form, send it in, have a judge say you're supposed to get it. So you still get that, but it's been chipped away a little bit because you got to show you're still entitled to it. I wouldn't be surprised if we don't eventually lose the right to future medical benefits in Kentucky. Other states don't have that. Indiana doesn't have that. Once you reach maximum medical improvement, you don't have any more medical benefits in Indiana.
Wow.
So I wouldn't be surprised if, we have more changes that are probably not beneficial to the injured worker, underneath the theory that it will minimize the cost of workers' comp insurance and therefore make it more attractive to have employers come to Kentucky. My experience over the last 33 years is almost always these changes don't help the employee. Every now and then they do, but almost all of them are designed eventually to help the employer and minimize cost. And I would expect that to continue for a long, long time. Some of the stuff that you have right now could get changed, the law, even though you might consider it to be grandfathered in. I've had some things that were changed that I thought were grandfathered in, but wouldn't be. And I don't want to get too complicated here, but the legislature has the right to change a lot of things. Generally, when they make those changes, it's not to your benefit. Motion to reopen, benefits you can get from reopening, those have all been changed, usually to the detriment of the injured employer. I wouldn't be surprised even if you keep your right to reopen, it might be minimized from 4 years to 2 years. I just see a lot of little things like that happening down the road. So even though we know what happens in a workers' comp claim now, the law will end up changing at some time, and that will have a big impact probably on what you're able to receive down the road.
That makes sense. Well, friends, I hope you found this interesting. I mean, there's a lot of ground to cover here, and we've endeavored to do that here in the past 30 minutes or so. But again, workers' compensation is not a fast process, but in the state of Kentucky, it's actually a really good program. It's much better than a lot of the other states, and it's something you did, if you've been injured on the job, if you've been hurt at work, it's a good reason to go ahead and get the process started. You may need to hire an attorney. And Scott, if somebody wanted to pick up the phone and get a hold of you, what's the best way for them to do that?
The best way is to call my phone, which is 502-937-5287, 502-937-5287. Even if you call after business hours, we'll call you back. And another way to reach me is through my website, which is ScheynostLaw.com, ScheynostLaw.com. We have a contact form there that you can fill out and send that in to me. And in my personal email address at work is ScheynostLaw.com. Again, you have to be able to spell Scheynost to do that. But if you send me an email, I'll respond to that. And you can fax stuff to us at 888-270-6527. You can drop by the office. We're happy to see you. I like to talk, so that works out pretty well. But in any event, reach us. We handle these on a contingency fee basis, which means we don't charge you anything unless we recover money for you. There may be some expenses and other costs that we have involved in this that we may have to charge you, but it's a free call. You don't have anything to lose. I'm not charging you by the hour. Again, I like to talk, so we'll be happy to talk to you about your workers' comp claim. And I don't think you got anything to lose by contacting us.
Outstanding. Friends, once again, I will put all of that contact information in the show notes, so it'll be really easy for you to find wherever you're listening to this podcast episode. So be sure to tune in, follow us on Facebook, follow us on the website there. We always post these up and make it very easy to find. And we'll be back in a few weeks here to have another couple of episodes and another great conversation with attorney Scott Scheynost. Scott, thanks for your time, guy.
Enjoyed it. Thank you, Jim.
Yeah, absolutely. Bye-bye. Thanks for listening to this episode of Hurt at Work. Scott will be back in 2 weeks with a new episode. For more information, be sure to visit ScheynostLaw.com. That's ScheynostLaw.com. You can also follow Scott's Workers' Comp office on Facebook. Until next time, be safe and remember, Scott's ready to help, especially when you and your family need it the most.